In this video, I'm going to break down exactly what constitutes defamation under Florida law. I'll reveal the 4 critical elements that determine whether you have a case or you're facing one. I'll also show you 2 devastating multi-million-dollar cases that will change how you think about every public statement your business makes. By the end, you'll understand the 3 essential strategies that can protect your company from these reputation-destroying disasters. I'm Santiago Cueto, board-certified international business law expert and best-selling author. And in my nearly 30 years of practice, I've seen how one careless statement can destroy decades of business success overnight. Now, what makes Florida defamation law particularly dangerous is how it balances free speech with the business protection, often in ways that surprise even experienced entrepreneurs. Let's start with the foundation. Florida defamation law protects both individuals and businesses from false statements that damage their reputation. But understanding what actually qualifies as defamation can mean the difference between winning a lawsuit and losing everything. Now, under Florida law, defamation requires 4 specific elements, and missing even one can make your case worthless. First, someone must make a false statement of fact. This is crucial because opinions, no matter how harsh, generally aren't defamatory. If someone says, "I think XYZ company provides terrible service," that's usually protected opinion. But if they say, "XYZ company stole money from my account," that's a statement of fact that can be proven true or false. Second, the statement must be published to at least one other person. This doesn't mean printed in a newspaper. It means communicated to someone other than the person being defamed. A private conversation between you and the subject isn't defamation, but posting the same thing on social media absolutely can be. Third, the statement must cause damage to reputation. In Florida, this doesn't always require proving specific financial losses. Some statements are considered so damaging that harm is presumed. These include false accusations of criminal behavior, claims that someone has a loathsome disease, statements that attack someone's professional competence, or accusations of sexual misconduct. Fourth, there must be some level of fault. For private individuals, this usually means negligence, but for public figures or businesses involved in public controversies, Florida requires actual malice, meaning the person making the statement either knew it was false or acted with reckless disregard for the truth. Now, here's what makes Florida particularly challenging for businesses. The state has strong anti-SLAPP laws designed to protect free speech, but it also recognizes that businesses can suffer massive financial harm from false statements. This creates a complex legal landscape where the stakes are enormous on both sides. Now, let me tell you about a case that perfectly demonstrates how devastating defamation can be for businesses. In 2018, a large construction company based in Tampa was hired to build a luxury condominium complex in downtown St. Petersburg worth over $300 million. 3 months into construction, a former employee who had been terminated for poor performance began posting detailed allegations on social media, claiming the company was using substandard materials, falsifying safety inspections, and bribing city officials. The post went viral and were picked up by news outlets, leading the condominium developers to terminate the contract within 6 weeks. 3 other major projects were canceled by nervous clients, and the company's bonding capacity was reduced, creating a total financial impact exceeding $47 million. Although the construction company ultimately won the defamation lawsuit by proving the allegations were false and made with actual malice, the reputational damage was so severe they filed for bankruptcy during litigation, demonstrating that legal victories don't always restore lost businesses. If you're starting to see why protecting your business reputation is so critical, and you want to make sure you never miss legal insights that could save your company from these devastating scenarios, hit that like button right now. And subscribe to my channel so you'll be the first one to know when I break down more of these costly business lessons. Trust me, the next case shows how even bigger companies aren't immune to these disasters. Now, our second case involves an even more sophisticated defamation disaster that destroyed what should have been one of Miami's biggest tech success stories. In 2020, a Miami-based fintech startup was preparing for a Series C funding round that would have valued the company at over $200 million when a competitor's executive allegedly sent a detailed email to potential investors. The email claimed the startup's technology was based on stolen intellectual property and that the founders had previously been involved in securities fraud. Now, the email was sent over to 50 potential investors and venture capital firms, causing the funding round to collapse immediately as investors pulled out to avoid potential liability. 3 major retail partners terminated their agreements, citing concerns about working with the company under investigation. The startup ultimately proved the statements were false and motivated by anti-competitive animus, winning $68 million in damages, including punitive damages. However, by the time the case was resolved after 18 months, the startup's technology had become obsolete. Their team had dispersed, and the market opportunity had passed, forcing them to liquidate assets and shut down despite their legal victory. This case demonstrates how even winning substantial damages can't always restore what defamation destroys in fast-moving industries. What makes modern defamation particularly dangerous for Florida businesses is how quickly false information spreads online and how difficult it can be to contain the damage. Social media platforms, review sites, and industry forums can amplify defamatory statements to thousands of people within hours. Florida courts have recognized that online defamation can be even more harmful than traditional media because of its performance and searchability. When someone Googles your company name, negative and false information can appear in search results for years, continuing to damage your reputation long after the original statements were made. The state has also grappled with issues of anonymous online speakers. Florida law allows plaintiffs to subpoena internet service providers and website operators to identify anonymous users who post defamatory content, but this process can be time-consuming and very expensive. Another critical factor is the concept of republication. In Florida, every time someone shares, tweets, or forwards defamatory content, they can potentially be held liable for republishing the defamation. This means that even employees or supporters who share false information about your competitors could expose your business to liability. Based on these cases and the evolving landscape of digital defamation, here are 3 strategies that could protect your business from these reputation-destroying disasters. First, implement comprehensive social media and communication policies for all employees and contractors. These policies should clearly prohibit making false statements about competitors, customers, or business partners. They should also establish approval processes for any public statement about legal disputes, business relationships, or industry controversies. Remember, in Florida, your business can be held liable for defamatory statements made by employees acting within the scope of their employment. Second, establish robust reputation monitoring systems that can quickly identify potentially defamatory content online. This includes setting up Google alerts for your company name, monitoring review sites and industry forums, and using professional reputation management services for early detection. The key is catching defamatory content quickly, because Florida law recognizes that the longer false statements circulate, the more damages they can cause. Third, you want to maintain detailed documentation of your business practices, relationships, and communications. In defamation cases, being able to quickly prove that allegations are false can be the difference between swift resolution and prolonged litigation. This includes keeping records of employee performance, contract compliance, safety procedures, and any other areas where competitors might make false claims. Additionally, consider obtaining media liability insurance that covers defamation claims. This specialized coverage can help with both defense costs and damages, and it often includes crisis management services that can help minimize reputational damage while legal proceedings are ongoing. The harsh reality of Florida defamation law is that your business reputation can be your most valuable asset and your greatest vulnerability simultaneously. The 2 cases we examined today show how false statements can destroy companies worth hundreds of millions of dollars, even when those companies ultimately win their legal battles. In our digital age, the speed and reach of defamatory content means that prevention and rapid response are more critical than ever. Legal victories are meaningful, but they often come too late to save the businesses that have been damaged. As someone who's guided companies through these exact scenarios, I can tell you that protecting your reputation requires the same level of strategic planning as protecting your intellectual property or financial assets. It's not just about having good lawyers. It's about having good systems and processes in place before problems arise. Now, if this breakdown of Florida defamation law helped you understand how to protect your business from these reputational disasters, I'd really appreciate a like on this video. It helps other business owners find this crucial information. And make sure to subscribe to my channel for more insights that can safeguard your company's most valuable assets. Because in business, your reputation truly is everything. And in Florida, the law reflects that reality. I'll see you in the next one.